All right, everyone, welcome back to the Granite Files, where we have been investigating the county of Henrico putting a chemical drug into the community drinking water. Lately, we have been covering Henrico County's demure, and so as I'm writing this up, there's a lot of things that kind of go through my mind that I want to share with you. So, for those of you who may be joining us for the first time, I filed for a declaratory judgment asking the judge whether or not Henrico County possesses the lawful authority to put fluoride into the drinking water. Is it legal? That is the controversy. Yes or no? If the judge determines that it is unlawful for the county of Henrico to put diluted hydrofluorosilicic acid into the public drinking water, then I'm asking the judge to force Henrico County to stop. Okay? If it's not legal to put fluoride in the drinking water, then Henrico needs to stop, right? That is what I am requesting from the court. And then I've also done a writ of mandamus to compel Henrico to provide pure water as defined under the law. Now, if the judge determines that Henrico does not possess the statutory authority to put this chemical contaminant into the drinking water, and the judge forces the county of Henrico to stop contaminating the water with this chemical drug, then by default we get the writ of mandamus to provide pure water. So that's where we stand. Now, I've been writing up my response to Henrico County's demurrer, and this one piece of case law just really boggles the mind, okay, that they even cited it. So I will read to you the paragraph that Henrico wrote, as well as the case law that they cited, and explain to you why I find it remarkable that Henrico County put this in their demurrer. It works in my favor, in my opinion, so I'm kind of surprised. I'm starting to wonder if they just filed this demurrer just to bide time to try to figure out how to how to come up with a legal strategy. So let's get into it. Henrico says, thus, state and federal courts have unanimously held that the introduction of fluoride into public drinking water does not violate any constitutional protected liberty interest. And then they cite Pure Water Committee of Western Maryland versus Mayor and City Council of Cumberland. This is going to be 2003. So the Pure Water Committee versus the Mayor and City of Cumberland case is somewhat interesting. Cumberland has a very I don't know how to put it, a very interesting past when it comes to water fluoridation. So they have voted multiple times to explicitly keep fluoride out of their drinking water. I believe they first put in their city charter in 1963. No substances shall be added to the drinking water for no substance shall be added to the drinking water for preventive health care purposes unrelated to the contamination of water. So that's the same language that is in the Federal Safe Drinking Water Act. So they repeatedly voted to keep fluoride out of the drinking water. They went so far as putting it into their city charter. There's an ordinance. They do not want this stuff in the drinking water. In the 1980s, there was this rogue mayor that wound up putting fluoride in the water, and there was some legal back and forth, and ultimately the fluoride was taken out of the water, and then again they made sure that it was in their city charter, no fluoride allowed, okay, to put it plainly. So I'm kind of surprised that Henrico put this case in. Now, why did this case fail? right? So the plaintiffs did fail. And the reason being was that the plaintiffs did not live in Cumberland, right? So the judge said, because you don't live in Cumberland, or also Frostburg was listed in this case. So because you don't live in Cumberland or in Frostburg, you don't have any standing. Now, this situation, the plaintiffs were receiving fluoridated water from Cumberland. They just didn't live there. So let me give you an example. Occasionally, you will have these small counties where maybe there's 4 people, right? You only have 4 people that live in this county. And they don't have a police department and they don't have a fire department. So a lot of times what will happen is the neighboring city will assist if the citizens should need 911, police or fire, right? And so the neighboring city will assist those 4 houses as a type of charity, right? Now, these 4 houses that live outside of that jurisdiction, they don't have a right to vote. Just because you're receiving charity from that locality does not grant you the authority to vote in their local elections. And so that's kind of the way that this was framed, almost like the water was being done as a matter of charity. Now, when it comes to Eastern Henrico receives water from the city of Richmond. This is not a form of charity, in my opinion. There's a contract between Richmond and Henrico. The contract was signed many years ago, and the contract is in place for many years, okay? So there's money involved. This is not charity. And so this is not that type of case. If somebody in Eastern Henrico has a problem with ingesting fluoridated water, in my opinion, they should go after Henrico County, because Henrico County is the ones that have a duty of care and a legal obligation to make sure that Henrico County is being given pure drinking water as defined under the law, right? So in my opinion, Henrico County cannot get into a contract with Richmond to then drug Eastern Henrico. You don't have the authority to get into a contract to drug Eastern Henrico. That's like saying, I'm going to get into a contract with my neighbor Sally in order to drug Bob. I can't get in a contract with Sally to drug Bob. It doesn't work that way. Henrico, in my opinion, doesn't have the authority to get into a contract with Richmond to drug Henrico, Eastern Henrico. And I'm not even sure if there is any language in the contract that Henrico signed regarding water fluoridation. To me, it's kind of irrelevant. If it's not in the contract, then Eastern Henrico, that's problematic because it's not in the contract and they're being fed fluoride. If it is in the contract, it's problematic because Henrico didn't have the legal authority, in my opinion. Okay, so there's that. Back to this case. So in this case, they voted multiple times. Cumberland voted multiple times not to have fluoride in the drinking water. They went so far as to put it in their charter. They went so far as to put it in the ordinance, okay? So there was a type of due process. And so it's remarkable that the county of Henrico uses this case to discuss constitutionally protected liberty interest. Constitutionally protected liberty interest is anything in the Constitution, essentially, you have a liberty interest too. So, for example, the First Amendment, that's in the Constitution, you have a liberty interest if your free speech was violated, okay? Another constitutionally protected liberty interest is freedom of religion, freedom to redress your grievances to your government, and of course, a constitutionally protected liberty interest is, in fact, due process, right? And so this case really highlighted that there was a lot of due process, right? A lot of due process. In 63, there was due process. There was some more due process that went on in, like I said, I believe there was something that went on in 88. They then again reaffirmed in their charter in, I believe it was like 1990, expressly saying there was a vote. Again, there was a vote to make sure that this language is going to be strong to forbid fluoride. And then in 2000, what happened was there was a referendum to repeal the language in the charter, okay? And so that's where this lawsuit came in, because the plaintiffs felt like they should have had a right to vote regarding in this election. It was a referendum. So the plaintiffs thought that they should be entitled to vote in this referendum that discussed repealing the language in the charter. Now, what's interesting is, the language was repealed in the charter, but they never voted to put fluoride back into the drinking water. So there was actually never any legislation to put fluoride back into the drinking water after 2000, okay? So it just shows, again, due process. Due process is voting, right? That is part of due process. That's one example of due process, I should say. Now, this case is as far as standing goes, like I said, the plaintiffs failed because the judge did not feel like they had standing because they did not live in Cumberland. I live in Henrico County, so this doesn't apply to me. I absolutely have standing. I live in the county of Henrico, where the fluoride is being added. So absolutely I have standing. So all this does, in my opinion, is bolster the fact that I do have liberty interest, constitutionally protected liberty interest, and that Henrico County, in fact, violated my constitutionally protected liberty interest. So I don't know what is going on with the county, who decided to put this piece of case law in here, because it does not work in their favor, in my opinion. I'm not sure. Maybe in their additional information that they're going to give to the judge, maybe they'll come up with something. I don't know what you're going to come up with, but maybe they're going to come up with something. The last thing I wanted to tell you that I didn't want to forget this is, there is a piece of case law where it was the Indiana Supreme Court. And what happened was that the folks were putting fluoride into the drinking water without an ordinance. And the Indiana Supreme Court said, yeah, you can't do this. Okay, so the plaintiff succeeded. And that is a similar situation of what's happening in Henrico. They're putting it in their drinking water. There's no ordinance, right? You can't do that, in my opinion. That is the controversy. Now, even if Henrico decided they're going to wake up tomorrow and pass an ordinance to have fluoride in the water, I don't think that they would do that, because what it will do is highlight the fact that they've been putting it in the drinking water this whole time without an ordinance. So it shows that you knew you should have had an ordinance when you didn't, and you didn't. But the other reason why I think even if they did wake up tomorrow and put in an ordinance, why it wouldn't make a difference is because because Virginia functions under the Dillon Rule, you would have to have express statutory authority, right? It needs to be express statutory authority, necessarily implied, or essentially you would need to do it in order to carry out the wishes of the Virginia legislature. The Virginia legislature, they passed several laws requiring pure water. They never passed a single law that authorizes localities such as Henrico to put fluoride in the drinking water. Remember, they thought about it back in 1952, but they did not go through with it. And what was interesting in that 1952 proposed bill is in it, it said that the fluoride needs to benefit the health of the inhabitants of such city. And they scratched out that line in one of their drafts. It didn't make it to the final draft. So either they did not think that fluoride actually benefits the health of the inhabitants, or they had serious doubts that fluoride benefits the health of the inhabitants. Back then they know there was a lot more uprising about fluoride than it is now, believe it or not. That's the way it seems in the papers anyway. So, fluoride is not a nutrient. It does not promote health. What it does is it makes your teeth harder and more brittle and more prone to cracking. So there you have it. If you guys want to check out this case, you can Google it very easily. If you put in Pure Water Committee of Maryland, or you could put Western Maryland versus Mayor and City of Cumberland 2003, and you tell me if whether or not you think that this piece of case law helps Henrico, or does it help me? Remember, they did not have standing in Cumberland because they did not live in Cumberland. I live in Henrico, therefore I do have standing. The liberty interest angle is due process. They show that there was a lot of due process, lots of voting, at least 3 elections regarding water fluoridation. Henrico has none. There's been no legislation, nothing. So again, I think this just highlights how my constitutionally protected liberty interest has in fact been violated. So that would make Henrico's actions unlawful. They are acting under the color of law, and I think that that's going to be a problem. But that is my opinion. Everything in here that I'm discussing, this is alleged, right? Everything is allegedly, in my opinion. Okay, guys? So thanks for joining me. Make sure that you give a thumbs up, leave a comment below, share it with somebody else, and I will see you next time. Bye, guys.